The leak of a draft Supreme Court opinion.
The Supreme Court.
The court that dark money built.
Breaking news at the Supreme Court.
The landmark Roe v. Wade case.
A woman's constitutional right to an abortion.
My body, my choice.
And Leonard Leo, who really is responsible for helping Trump fill the Supreme Court.
A Supreme Court decision with dramatic consequences. The justices ruling 5-4.
You look at the decisions like Shelby County that attacked voting rights, and then you look at the dark money cases like Citizens United. It's not just Dobbs.
The court is not in order. This is Senator Sheldon Whitehouse, and welcome to Making the Case. This episode will cover the Dobbs case and the Supreme Court leak related to the Dobbs case. For this, I'm joined by Timmaraju, who's the president of NARAL, former senior advisor to the Biden Office of Personnel Management, and chief of staff to Representative Amy Barra. And I'm joined by Leah Litman, professor of law at the University of Michigan Law School and host of the excellent Strict Scrutiny podcast, an expert on constitutional law and federal courts, who clerked on the Sixth Circuit and for Justice Anthony Kennedy. And I'm joined also by my distinguished co-host, Representative Hank Johnson, Democrat from Georgia's 4th District, who chairs the House Courts Subcommittee to parallel with my Senate Courts Subcommittee. So let me start, Leah, asking you about some of the history that led up to the Dobbs case. We all recall the right-wing operation that has focused on the Supreme Court and that had mantras like no more Stevenses and no more suitors, with the goal not to nominate anyone that the big funders couldn't trust to rule the way they wanted. On the flip side, we saw judges like Brett Kavanaugh auditioning for their Supreme Court seats with radical opinions and multiple Federalist Society speeches. How did that operation yield the Dobbs decision? How did the two connect, Leah?
So the Federalist Society does several things, but one of the things that it did here is it served as a mechanism to identify people who had certain views, including views on abortion and reproductive justice, because what they were trying to avoid was a situation where they would appoint someone who was just good at the law and who wanted to uphold the law and reach their independent views. And instead, they wanted to be confident that they would appoint someone who would, among other things, overrule Roe versus Wade. And so by creating this structure, the Federalist Society with multiple speaking events, conferences, and a network that allowed them to get to know one another and figure out through extensive executive branch service, extensive involvement in, let's say, the Bush campaign, the Bush legal campaign, as well as various speaking events, and then later on as a judge, it allowed them to figure out what their views were, and that allowed them to pick people that they knew would overrule Roe versus Wade. And it took them decades to kind of perfect this, but they did it, and that gave us the court that we have today.
Sounds like a captured court. Let me turn it over to Hank.
Well, thank you, Sheldon, for having me again to co-host with you, and good to be with our panelists today. And yes, the Federalist Society has done a pretty neat job of arriving at a 6-3 supermajority court, all of whom on that 6-3 majority are members of the Federalist Society and steeped in their anti-abortion and anti-female reproductive rights issues. They've been kind of indoctrinated since law school, all the way through their professional careers and ascension to the bench. And in Dobbs, when they finally got an opportunity to overrule Roe, Justice Alito said that there's no right to an abortion because that right isn't in the text of the Constitution, and nothing in the Constitution implicitly protects that right because it isn't, as he put it, deeply rooted in this nation's history and tradition, or implicit in our concept of ordered liberty. There's a lot wrong with that, but what do you think is the biggest flaw in that reasoning?
Oh my gosh, so many things to say. I think, We can't underestimate the political movement started by Donald Trump and sort of sealed by Mitch McConnell to stack the court, right? So it was like decades of planning and then opportunity. And I think that's really important to contextualize. This is extremely politicized court. So Justice Alito appeared in front of the Senate Judiciary Committee, and in this opinion, he contradicted his own testimony. And I think that's an important thing to understand going into the debates that Senator Whitehouse and his colleagues are going to have about the court. You know, we have an extremely politicized court, but, you know, he also implied that other rights based on the 14th Amendment are not necessarily endangered because abortion is fundamentally different, right? That is something we've heard him underscore. So we know that for a long time, outlawing abortion wasn't their end game. It's important to look at the opinion. It's important to look at the dissent from Justice Thomas and understand that they're going for the broadest range of fundamental freedoms for women, pregnant people in this country. They're going after birth control. They're going after not just abortion access, but the full range of care. And they've made it very clear and they've laid it very bare. The Dobbs decision is laying the foundation for reconsidering a host of other fundamental rights.
Well, thank you. It's important to note that Justice Thomas somehow, for some reason, left out Loving versus Virginia as one of the items that were on the chopping block that are not explicitly stated in our Constitution, derived through this right to privacy.
For viewers who don't know the case, Loving versus Virginia was...
white people and black people can get married. There's a right to marry who you want to marry.
Surprising that was the case, but those are the days that these guys harken back to.
That's like, it's the early 60s. They're trying to take us back even further than that when it comes to reproductive rights and perhaps voting rights as well. But in their dissent to the Dobbs case, Justices Breyer, Sotomayor, and Kagan said that, quote, "The court reverses course today for one reason and one reason only, because the composition of this court has changed," end quote. These are some of the strongest words we've heard from our justices against each other. Minnie, why is it so significant that the dissenting justices pointed this out so clearly?
Yeah, I think it goes back to the point that I was making about the politicized nature of this court. You know, for decades we've, and I was a very poor law student, so I'll say from law school, but also just in, public education in this country, we're told that the Supreme Court is a nonpartisan court. They are unbiased. They are interpreting the Constitution. They are looking at precedent, right? All the standards that we expect this court to uphold when they're reviewing critical decisions like this are out the window, right? By saying that, the dissent saying that, it's the makeup of this court that has changed this interpretation versus the law and the interpretation of the law in an unbiased manner. They're calling to question the impartiality of this court, and they're opening up for us a much-needed dialogue about the credibility of this court. And I think that's so important because it's opened the door for this public debate. And now compounding that with the leak, the lack of confidence in the court as a result of the leak, like unprecedented, right? Plus the decades of precedent they've overturned, as well as the fact that this is the first time a right has been eroded versus expanded by this court, have, led us to record low levels of approval for this court. So it's an opportunity for us, organizations like ours, to start making the case to supporters of abortion rights and other fundamental freedoms that the court has to be held accountable by Congress.
Leah, you served on the court as a clerk for Justice Kennedy, so you have some direct experience here. In terms of the dissent calling out the Dobbs decision as being based on composition of the court, not principle, And in terms of unrolling a brand new history and tradition standard, how exceptional was this in your view?
I think this was a very momentous and significant decision, but I also think it's important for people to understand that not only has this been in the works for a while, but the court has been steadily trending in this direction with the kinds of appointments that the Federalist Society, Republican presidents, and Republican senators and the conservative legal movement have been pushing. So when I clerked on the Supreme Court between 2011 and 2012, the justices came within one vote, one single vote, of killing the entire Affordable Care Act, health insurance for millions of people, based on their fears that the government might one day make you buy broccoli or eat broccoli. So it's not like things at the Supreme Court were going super well before President Trump named 3 justices to the court. It's just that they got so dramatically worse that it led 3 justices, Justices Breyer, Sotomayor, and Kagan, to write a dissent in one voice saying not only, the only reason this happened is because the composition of the court changed, but also the currency of the court's opinion is power and not reason. And so this decision is, I think, a very significant event. I mean, the consequences were already immediate. Every month, basically every week, every day, there is an additional story about a person whose life, whose health has been put into danger because of the laws that the Supreme Court said could go into effect. So this was a really important event that should cause people to pay attention. But the reality is this campaign has been steadily chipping away against the integrity and institutional structure of the Supreme Court for the last few decades.
So it's not just a question of a bad decision substantively. It's actually a really significant signal about a change in the way the court operates and as noted by the dissenting justices.
Yes, absolutely. If they were willing to go out and say this in the pages of the U.S. reports, it's really bad because their incentives are to keep their heads down, the Democratic appointees, to play nice, right, to say nice things about their colleagues because they need to work with them in cases and get their votes. So the fact that they were willing to sound an alarm to this extent should be grave cause for concern. We shouldn't count on them to be the ones leading this fight, but the fact that they are, let's say, saying all is not well at 1 First Street should make us willing to continue on.
Yeah, pretty strong signal when you consider the omerta, that is the customary behavior of the justices about each other. So many mentioned the leak. The leak was a bit of a tell. The leak provoked a couple of things. First, an irate response from the Chief Justice, who said, by gosh, there's going to be an investigation. And then ultimately there was a report of investigation, which, as somebody who's done a lot of investigations, I found some pretty obvious faults with, not the least of which is that some of the prime suspects were the justices themselves. If you're just looking at logically who had access to the material and who had a motive to leak it, it was justices. And yet they got very special treatment in the court's so-called investigation. Leah, what do you make of the Marshal's investigation and why it turned out the way it did?
The Marshal's investigation was doomed to fail from the outset. It was never an independent investigation. It was run by employees of the court, and those employees were kind of asked to kind of, sort of, but not really investigate the people who they work for.
That's like investigating your boss.
So it's no surprise that they didn't really do much investigation at all. I mean, even with respect to other employees of the court, the reports that have come out about what this investigation entailed is they asked employees into a room and then kind of said, did you do it? And that was the investigation. And then somehow, based on all of this, Justice Alito is giving interviews to the Wall Street Journal that say, I know who did it. Like, I have a hunch, though I'm not willing to name names. I mean, the entire thing is just a disaster, but is emblematic of a court that has abandoned a willingness to be subject to the law and accountable to anyone else but themselves. And when that is a structure they have created, they have doomed themselves to fail, because our government is not supposed to work where you have 9 people who are above the law and above the rules. And when they are allowed to be that way, then this is how they behave in just frankly ridiculous ways.
I don't remember the exact language, but there was the report, the investigative report that the marshal of the court put out. And then the court, presumably the Chief Justice, put out kind of a cover memo to the report of the investigation, in which it opened with the assertion that this was a very serious matter. It was no mere attempt at objecting to or blocking the court's decision. Again, I don't have the language exactly right, but clearly what that language did was impute a motive. And it imputed a motive that would only have been pertinent to those who had objected to the decision, i.e. to the more liberal chambers and to the more liberal judges. Was there any foundation for putting the onus for the leak on the objecting justices, as opposed to, say, the justices who might have wanted to shore up a strong majority by leaking a strong opinion to scare wobbly justices away from negotiating a milder outcome?
No, there was no substantiation given whatsoever, but that's emblematic of how this is kind of a fact-free court. They just declare the facts as they would like them to be, rather than as the way they are. They offered no evidence or substantiation for the insinuation that the leak came from someone who objected to the court's opinions. And all they did is they appended kind of a note from their friend, Michael Chertoff, who said, this investigation seems nice to me, right? I can't think of anything else that I would have done. But no, they never provided any support for the insinuation in that first opening cover memo from the Chief Justice.
And just, I like Michael Chertoff, and we've worked together, but talk about a thankless job. Like I said, I've done a lot of investigations, and the grand jury does a report or the investigative entity does a report, and you come out with your conclusions from your investigation. I've never seen an investigation that attached to itself a sidecar saying, oh, and by the way, this was a good investigation. I mean, I see Minnie shaking her head
Wild.
Here. It just is not normal behavior, and you'd think that they'd be trying to strive for normal behavior.
Yeah, it was kind of like a certification of the investigation, which was doomed from its inception. I mean, how can the boss hire an employee to investigate the boss and the operation that's run by the boss? It was doomed to fail to begin with, especially given the fact that the Supreme Court Marshal's office doesn't even have the professional expertise or capacity to carry out an investigation. Do you have any suspicions about the investigation in terms of who it was entrusted to from its inception?
No, I mean, because they are not willing to reveal anything about this investigation other than to say they wrapped up and to append a note saying this was definitely a good investigation, but we won't kind of tell you more than that. I mean, other than that, the marshal was in charge of it. That's kind of all we know. And we, of course, know that the marshal reports to, the justices and the court itself, but we don't really know much beyond. They asked some questions, and that was kind of it.
Well, now, they treated apparently the staff and court personnel differently in this investigation than the investigators treated the justices and the Chief Justice who they did talk to. Can you tell us a little bit about how that happened?
Yes, so they asked the employees to sign affidavits and also to turn over electronic devices. The justices were apparently not asked to sign affidavits, nor was there attempt to account for, say, their personal devices. Now, in the course of detailing, we did this investigation, it turned out that actually they couldn't even account for all of the devices at the Supreme Court or at the justices' homes. That is, these devices did not keep track of documents that were printed more than some number of days ago, and so they couldn't actually account for when this opinion might have been printed out and circulated. So what we know is this investigation just was not actually equipped or capable of uncovering some of what it purported to want to know.
I want to take you back to the Dobbs decision. Justice Alito said that Dobbs was undoing Roe's error by returning the question of abortion to the states. But these are the same states that the Supreme Court has let Republicans gerrymander to no end. And those Republican states have enacted extreme abortion restrictions resulting in untold suffering for women and putting doctors in impossible situations across the country. Why was it a hollow promise for the court to say that it was returning the question of abortion to the states? And I might add at this point that I just heard former Vice President Pence in his speech declaring his candidacy for the presidency that he would not rest until abortion was illegal in all 50 states. Mm-hmm. But can you talk to us a little bit about this plan to overturn abortion based on wanting to turn it back to the states?
Sure. So by giving it back to the states, what they really meant is we're giving it back to state legislatures. At the same time, we have allowed state legislatures to insulate themselves from the will of the people. So there are a few great examples of this. Take Wisconsin, which is one of the most gerrymandered legislatures in the country. Wisconsin has on the books a abortion ban that was passed before Roe versus Wade. And a majority of Wisconsinites, right, don't believe abortion should be banned under all circumstances. But because that legislature is so gerrymandered, the people can't actually get the legislature to repeal the pre-Roe criminal abortion ban. So yes, the court has returned this issue to the states, but they've directed that it can and should be resolved by the office within the state legislature, that the court has allowed to insulate itself from the results of elections, from the will of the people, and from the will of the voters. And people are seeing the disastrous consequences of this on their lives every day. I mean, Florida is another great example. You know, that state also passed an extreme gerrymandered map. They didn't allow, effectively, the state constitutional amendment that restored the right to vote to people who were convicted of felonies. And as a result of that, got a state legislature that was extremely gerrymandered, and they passed, restrictive abortion laws after Roe versus Wade, abortion bans. And again, every month we are reading stories about the women who were tortured, within moments of death because they could not receive the medical care, right, that doctors needed to provide to them. They could not receive abortion care, and so they were forced to bleed out, right? They risked becoming septic. And that is what the court allowed state legislatures to do, and then experience very little electoral accountability or political consequences for doing so because they are so gerrymandered and insulated from the will of the people and the results of elections.
Thanks to other Supreme Court decisions, which is actually really good segue, Leah, your point, to Minnie's experience here. Minnie, how would you describe the consequences of this decision for women and girls and their doctors? And where does this leave us for the future of the reproductive rights movement?
Yeah, I think Lee did a great job of summarizing the root cause and what's really going on in the states. I just want to add a note that we now are tracking 20 states with abortion bans and restricted access. But it's also important to note we have 22 states, plus the District of Columbia, that have put some sort of abortion access protection in legislatures. So the gerrymandering and the restricted access and the safeguards of democracy being eroded in those really problematic red states, predominantly in the Deep South, where we have an abortion access desert, is alarming and terrifying. The hope is where we see states that have democratic safeguards in place where we're able to make progress, like the trifecta we were able to just elect in Michigan, which is incredible. And now we have enshrined in the Constitution. Gretchen Whitmer is repealing zombie laws. It's very exciting. So it's important to see both sides of it because I don't want supporters of abortion rights and democracy to lose hope. But I also want to mention, as you know, there's an ongoing federal case that could effectively ban the abortion drug mifepristone in all 50 states. So even in states like Michigan, California, New York that have access protections, we have the threat to the most popular form of abortion care, which is medication abortion. And that's also due to a problematic and corrupt court, right? So you could draw the line between all of these restrictions. And to your point, Congressman, about Mike Pence, the threat of a federal abortion ban looms large. I'll just say anecdotally, I just saw some Susan B. Anthony List lobbyists in the House. So I think that they're actively working on it. Let's not get complacent. And if we lose the House and the Senate, we can be guaranteed they're going to push through that legislation. Going forward, the state of the movement, it's a multi-pronged approach. And it's really one of the reasons you and I connected recently, Senator, is because we've come to understand in reproductive rights that we also have to get deeply involved in court reform and democracy reform. So we have to continue to pass federal legislation. We've got to do our electoral work. We've got to make sure we have pro-choice majorities in the House and Senate and pass legislation like the Women's Health Protection Act and which would the Equal Access to Abortion Coverage and Health Insurance Act that would eliminate problematic Hyde Amendment restrictions on abortion care. And then in state legislatures, we need to continue to support ballot measures where we can go straight to the people and go around gerrymandered legislatures. Because when we go to the people, we know the majority of Americans are with us on reproductive freedom. And then finally, we've got to talk about those democracy safeguards. We've got to be robust in our support of voting rights. Without that, we know that we cannot advance reproductive freedom and court reform. We have to restore legitimacy of our judiciary after our opposition, embedded with the Republicans, has spent years attacking the federal bench with ideologues and advancing their out-of-touch agenda. So we want to make reproductive freedom voters, democracy voters, and defenders of the judiciary, the court, and the democratic processes. That's my goal.
Well, that's a perfect end to the podcast because this entire operation that led to the Dobbs decision is an anti-democracy operation. They tried for years and they couldn't get elections won. They couldn't get laws passed. So they instead stacked a court full of people who are not responsive to voters but will do what they said. With the new composition of the court, they actually changed the law to open up the Dobbs decision. So that sent it down to state legislatures where another set of Supreme Court right-wing decisions had opened up gerrymandering. And of course, the dark money operation that funds all of this is created and enabled by this Supreme Court, which it's the court that dark money built, but it also has built the dark money political operation. And I guess the only good news at the end of this is, Minnie, what you said, the public is fed up with this. They don't like the result of Dobbs. They don't like having decisions made by unaccountable judges. They don't like gerrymandering, and they don't like dark money politics. And the court is at the hub of all of that. And so it's going to continue to require our attention. And that is why Representative Johnson and I are going to continue making the case. Thank you, Minnie, and thank you, Leah, for your advocacy in this area. You are wonderful.
Thank you so much for having us.
Thank you.
Thank you all.